All right. Are you Mr. Jakari Seymour? Just nod your head, yes? Or okay. All right. Now calling the matter of State of Georgia versus Jakari Seymour, charged in warrant number 2024 CW 52110, aggravated battery. Attorney Rogers brought this motion. Go ahead, Attorney Rogers.
Thank you, Judge. Judge, Mr. Seymour is here on aggravated battery and related charges. I guess, so, first I'll say this in the 90-day situation. Our issue is more that, to my knowledge, and let me double check my notes real quick just for a kick. As far as I know from people, Mr. Seymour, and he doesn't have any felony convictions at this point. What he's charged about, just to lay it out for the court, it's an aggravated battery and related charges stemming from an incident at or near the airport. Essentially, Mr. Seymour is accused of using a knife against, I guess he'd be an airport work. I'm not sure exactly what agency he works for, but essentially supervisor regarding the shuttles at the airport. The charges stem from an altercation that occurred, which the specifics weren't really made very clear at the preliminary hearing as far as how the altercation started, anything like that. The charges are because Mr. Seymour is alleged to have used a knife, which cut the gentleman's nose. It's a significant injury. I don't want to downplay it at all. The issues that I have with what was testified to at the prelim and why I think it reflects on the charges that, I specifically asked the detective whether or not anybody could say who started the altercation as far as who took it, to a physical level from merely an issue about whether or not Mr. Seymour is going to get on this shuttle or that shuttle or whatever, which is what this all started about, is him riding shuttles. Got off one shuttle. He tries to get on another shuttle. Supervisor intervenes. When I asked about the specifics of how that intervention, was effective as far as putting hands on somebody, was a weapon presented? No, there was nobody asked the witnesses about that. The video is unclear about what exactly happened. Almost to the extent that what I took from what the detective said in the video, they're providing real probative evidence. It just seemed to show some commotion from a distance. Our position is that, Mr. Seymour didn't start the altercation. And I understand what the state's position is that he's been criminally trespassed. He's not supposed to be at the location. So I get it. I'm not saying that there was any issue with the criminal trespass part of it. What I am saying is that, to the extent that nobody can say who started the altercation, nobody asked the witnesses whether or not the other person presenting a weapon was armed or anything of that nature. The investigation is such that it started at the end with basically looking for evidence to charge this person with this particular crime, not to find out what happened, but just to support charges that were kind of already in motion. To that extent, I would say that, Mr. Seymour has a right to defend himself, and he would stand on that right at trial if it were to go that far. However, as it stands right now, he's 24 years old. He's been here for almost 10 years at this point. He lives with his grandmother and grandfather. That's where he came to live with them. It's his closest family. He also has a girlfriend here. Been working in photography and brand promotion, and also working at a cleaning service. But I can tell, like I said, Mr. Seymour is not, some sort of psychopath out here seeking to engage people in arguments so that he can use a knife against them. So for those reasons, the fact that there's no evidence, at least that I'm aware of, presented that was supposed to find that he's a risk of flight. Other than assuming his guilt before it's been proven, there's no basis to say that he's a risk to people or property in the community. While it's possible he may be convicted, it's also possible that a jury finds that he acted in self-defense. That hadn't been determined yet, so I would just ask the court to refrain from making that determination. Additionally, um, he's not a man of means. Like I say, he's 24. He's not a property owner. Um, he's in an industry that is not lucrative, at least when you start off. And so for all those reasons, Judge, I would ask that the court would consider setting a bond in the neighborhood of 30,000 between the charges that he's charged with. And I'll leave it there for the moment.
All right, go ahead. Attorney Thomas.
Your Honor, we had a somewhat lengthy hearing on this particular case on Wednesday, during which time the officer did testify that this gentleman was on one of the airport shuttle buses. He rode the bus all the way around, did not get off. Driver asked him to exit the bus. Initially, he did so, but when he tried to get on another shuttle bus, they asked him to get off. He refused to leave. When he tried to get on is when the supervisor attempted to stop him from getting on their bus, which they are entitled to do. At that time, this gentleman pulled out a knife and almost sliced this man's nose off. The officer had pictures of the injuries to the victim's nose and to his eyelid, and they're absolutely horrific. If taking defense counsel's argument that Mr. Seymour is entitled to defend himself, he did not defend himself with equal force. No weapon was used against him. They merely prevented him from trying to get back on that shuttle bus, which they are allowed to do. Now, the history of the case is that Mr. Seymour had previously been banned from the airport anyway. He wasn't supposed to even be there. But after slashing the victim, almost cutting his nose off, and I'm not exaggerating, Your Honor, I wish I was, he runs into the airport, the very place he's not supposed to be. Officers were able to recover the knife, and you can see portions of the altercation itself on the video. There are two witnesses in addition to the victim, so there's no doubt that this is the person who was involved in that altercation. Due to the severity and the nature of the injuries, the fact that none of this would have happened had Mr. Seymour complied with his previous criminal trespass warnings to not even be on the premises. And there may be argument that, well, he wasn't directly in the airport, where if you're on the airport shuttle bus, you're on the property of Hartsfield-Jackson Airport. It's not just the terminal, it's the property. He was banned from the property, from my understanding of the officer's testimony. And had he complied with that criminal trespass warning, none of this would have happened. His refusal to comply with the criminal trespass warning, his assault on the victim, who was merely acting in the capacity of his job, is what brought about this. So, Your Honor, state would ask that no bond be set in this matter. If a bond is set, Your Honor, state would reiterate that he is not to return to the premises and property of the Hartsfield-Jackson Airport, and he is definitely to have no contact and stay away from the victim in this matter, Quan Lawrence.
Any last words, Attorney Rogers?
Yes, ma'am. Thank you, Judge. Yeah, we certainly wouldn't have any argument, as far as the stay away conditions, things of that nature. I do want to respond to a couple of things that the ADA said about the circumstances. What I will say is that, I specifically asked the detective, did anybody ask whether or not the alleged victim presented a weapon? Because let's be clear, the witnesses are the subordinates of the alleged victim. These people he's a supervisor, these are people who work underneath him. And I say that just to say that, if we're not even going to ask, how the altercation started, be specific about it or anything like that, I think we're getting ahead of ourselves again. I specifically asked the detective, did anybody ask whether or not the alleged victim was armed or presented a weapon? Said that wasn't asked of them. So there's really no evidence or any testimony that I heard that would support a finding that Mr. Seymour just started this out of nowhere or anything like that. I, like I said, would stand on the fact that he doesn't have a record that would counsel against him receiving a bond. There's no basis to think
He
that.
does not have a record?
Yes, that's what I'm saying. Yes, ma'am. Yeah, yeah. I'm not going so far as to say he doesn't have any record. I think he might have a list, something like that.
He does have a record, Your Honor.
I'm not that far.
I would like to hear his criminal history, but go ahead and finish, Attorney Rogers.
Yeah,
Your thoughts?
my understanding is that he doesn't have a felony record, but and the reason I say that is just because one of the considerations in the bond is the risk of committing a felony pending trial. And my general position about that is that, short of previous felony convictions, to find that would require a person to assume the validity of the charge that we're here about. Furthermore, like I said, the lack of a flight risk, and I would say it kind of dovetails also into the lack of, to a person's criminal record, but the risk of committing, or the risk to people or property in the community, intimidating witnesses, things of that nature. There's no basis to say that Mr. Seymour would engage in such behavior that he's a significant risk. And I would also point out that's, the statute talks about significant risk. It doesn't say any risk. It doesn't say any possibility. Anybody charged with a crime could possibly do one of the things considered in the bond factor. That's always a possibility for a human being. The question is whether or not there's a significant risk and something more than just the mere possibility. And absent some sort of evidentiary basis to support, I don't know how the state can burden of showing that he's a significant risk of anything that would justify denying him a bond. So for those reasons, Your Honor, we stand on our request. We ask that the aggravated battery charge receive a bond. And since I just noticed that's the only one on the calendar, so I'll kind of mitigate my request to approximately $20,000 aggravated battery charge. But we wouldn't have any objection as far as to stay away from.
So do you think there are other charges that should have been on this calendar?
Not really, because they had bonds on them to my recollection. So I think that's probably what the situation was. It was only this aggravated battery charge wasn't on there. He's charged with, if I remember correctly, it's a criminal trespass charge, but it's all related to this incident. But the aggravated battery was the only one that didn't have a bond. Yeah, the aggravated assault and criminal trespass do have bonds. The aggravated battery doesn't. When I'm seeing on the jail.
There are two pending cases that I see, and I believe the officer did refer to this other case I'm looking at. It is related to this one. This officer is the one, once he realized the severity of the injury, added an additional count. So at some point, I would think that they're going to be joined together. But right now, it's showing two cases related to this incident, and
yeah, that's
just those two.
Yeah, the ag assault and the criminal trespass have bonds already. That's what the detective said was that it started off, I guess, the officers who responded charged that once the detective got a little more information, he went and sought the aggravated battery warrant regarding the.
How much is his aggravated assault charge? How much is that one?
The ag assault, what I'm saying at the jail, it makes quicker for me sometimes, it's $10,000. The criminal trespass, $1,000.
So how much is the aggravated assault charge? What is it set at right now for the aggravated assault? 10,000.
Yes.
Okay. And then the criminal trespass is set at what?
2,000.
2,000. Okay.
And the ag battery.
And then he just he doesn't have the okay. All righty. Attorney Rogers, anything else?
No, ma'am, that's all you have.
ADA Thomas, anything else?
Just very briefly, Your Honor. This gentleman has at least 2 misdemeanor convictions that I can see. He does not show any felony convictions, but there appears he has at least one probation violation regarding to the misdemeanor counts. There appears to be an escalating pattern of behavior. And again, I will refer the court to the 4 Ayala factors, one of which is the risk to the community and the propensity to violate or reoffend. Both of those would apply to this particular defendant. State would ask again that no bond be set on the count of aggravated battery.
How long has
Oh.
he been in custody?
Your audio got bad, Judge. I didn't quite catch that.
How long has he been in custody on this charge?
Since September the 11th, this just happened.
All right. All right, I'm gonna set the aggravated battery at 25,000.
Your Honor, would the court impose the condition of no contact and stay away?
Yes, no contact and to stay away.
Thank you, Judge.
All right. And does that conclude our calendar? Let's see.